Joseph M. Della Rata versus Barbara A. Larkin. This case took place in Glen Burnie. Glen Burnie has roughly 67,639 for a population. A Maryland District Court is also located here. The plaintiff, Joseph M. Della Rata, currently is a part of the National Italian American Foundation and has another business of his own, which is the Della Rata, and this is a commercial management company. The defendant is Barbara A. Larkin. In 1969, the Trinity Joint Venture Limited Partnership was formed in Maryland to develop commercially zoned property on Crane Highway in Glen Burnie. In 1967, Trinity admitted Joseph M. Della Rata as the general partner. On December 21, 1981, an amended partnership agreement was executed under which Della Rata became Trinity's sole general partner. Della Rata also was one of the partner's 13 limited partners. The agreement was amended on May 4, 1992 to change the name of the partnership to East Park. A further agreement was executed on June 1, 1992, substituting as limited partners the widows of 3 deceased limited partners, which one of the widows was Barbara A. Larkin. East Park developed a shopping center on its Glen Burnie property that over time grew to include 205,000 square feet of retail space. In 1992, the East Park obtained $9 million in financing secured by a mortgage on the shopping center. The loan provided for an interest at the rate of 9.375 per year and had a due date of January 1, 2003. In December 2001, Della Rata, a legal resident of Florida, created the Della Rata Intangible Asset Management Trust in order to avoid a Florida tax on intangible assets. When Della Rata's accountant prepared East Park's 2001 tax returns, he showed no ownership interest for Joseph M. Della. Instead, the K-1 schedules rejected that all of Della Rata's ownership interest in East Park has been transferred to the trust. After the tax returns were brought to his attention, Della Rata argued that this transfer was a mistake and filed amended correcting the alleged mistake. Now let's take this to court and see what happens. Order in the court. So, Della Rata, did you send a letter out on March 1st, 2002 informing East Park's limited partners that the loan would be due on February 3rd, 2003? Yes, I did, Your Honor. And did the letter state that the loan balance was over $8 million and it could not be repaid by East Park's cash reserves and that the capital call would be due on September 30th, 2002? Also, and each limited partner would be required to contribute some part of their share to the loan? Yes, I did, Your Honor. Mrs. Larkin, is this correct? You met with Della Rata on March 15, 2002 to discuss the capital call, and some of the limited partners were concerned about the meeting of the capital call and refinancing the loan was suggested as an alternative? Yes, we were very concerned. And Della Rata stated that he would contact lenders and try to commit to the loan? Yes. Okay, Della Rata. By his own admission, Della Rata therefore failed to expose refinancing options. So, Mrs. Larkin, is this correct? After the meeting on March 15th, you and some of your partners each gave a written notice to Della Rata stating your right to withdraw from East Park? Mrs. Larkin, is this correct? Yes. Alright, each withdrawing partner's withdrawal would be effective on September 29, 2002, giving more than 6 months' notice required. The limited partners did the right thing because the Maryland Code of the Corporation Associates article provides that a limited partner may withdraw on not less than 6 months prior written notice of each general partner at the general partner's address of the books of the limited partnership. So the partners have all the right to withdraw from the partnership. So Mrs. Larkin, is it true on May 24th, 2002, you withdrawing partners filed a complaint in the circuit court seeking that you guys properly had withdrawn from the East Park and were entitled to fair value of East Park's partners' interest, and that you guys also saw that an injunction barring enforcement of the capital call?
Yes, Your Honor.
Back to you, Del Rada. So is this correct? You wrote to the Withdrawing Partners Council on April 3rd, 2002, claiming that the agreement specified when the withdrawing partners' capital could be removed from the partnership and the withdrawing partners were not so entitled under the circumstances? Yes, Your Honor, this is correct. I stated that if the settlement offer was not accepted, the capital call would be accelerated and due on September 1st, 2002. Del Rada, did you claim that a default by the withdrawing partners in the meeting, the capital call, would result in them showing that they would give up in the interest in East Park? This is where Del Rada is wrong. He stated that the agreement specified when the withdrawing partners' capital would be removed from the partnership and the withdrawing partners were not so entitled under the circumstances. This is where the Maryland Code of Corporations and Association article provides withdrawing partners are entitled to receive distributions to which the partner is entitled under the partnership agreement, and if not otherwise provide in the partnership agreement. The partner is entitled to receive within reasonable time after the withdrawal the fair value of the partner's interest in the limited partnership as the date of withdrawal, based on the partner's right to the share in distribution from the limited partners. Alright, we're going to go back and look more into this case. So Mrs. Larkin, is it true on May 24th, 2002, you withdrawing partners filed a complaint in the circuit court seeking that you guys properly had withdrawn from the East Park and were entitled to fair value of East Park's partners' interest, and that you guys also saw that an injunction barring enforcement of the capital call?
Yes, Your Honor.
Alright, I'm issuing an option and an order. 1, I'm declaring Del Rada's assignment to the trust affected his withdrawal as general partner in Trigner East Park's dissolution. 2nd, I'm ordering East Park to wind up its business and distribute its assets to the partners. 3rd, that the withdrawing partners properly exercise the right to withdraw. And finally, permanently enjoining enforcement of the capital call against the withdrawing partners. Thank you for looking into this case. I hope you enjoyed it.